Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. This is our bi-weekly community conference call that we hold every other week. People post their questions online in our forums, and we go over those questions. And then, if there's time permitting, we go over new questions. Everybody's welcome, and we feel very privileged to be able to do this for the community. That said, let me get started right away. First, I want to deal with those questions. Right now, today, we have only two of those, which I consider to be frequently asked questions. Some of them can be so tricky that I think it becomes a matter of community service to make sure that we answer those questions for everyone. Can a TN worker work on 1099 as an independent contractor? This is a very misunderstood issue. I have not spent a whole lot of time researching this issue, but these are my preliminary thoughts. Let me tell you what the problem is. A TN can be set up in one of the two ways. Either a US employer directly offers employment to a professional from Canada or Mexico, and they come in as a treaty national. So direct employment, simplest case, W-2. They are a full employee of the company, US employer. So that part is easy to understand. The second way to set up a TN is if, for example, there is a company in Canada, there's a company in USA. The company in USA contracts with a company in Canada and says you send employee XYZ to us to work and we'll pay you and you pay the employee's salary. In that case, the US company is sending out a 1099 to the Canadian company. Another easy one to understand. Okay. The problematic cases are those where the US worker is being sponsored by, I'm sorry, where the Canadian worker is being sponsored by the US company and the US company wants to put them on a 1099. I think that is not a good idea. A lot of lawyers have said as long as employer-employee relationship exists, you can file a 1099. And that to me is a little short-sighted. Why? Because the difference between an independent contractor and an employee is the degree of control. If you are maintaining control as an employer, then IRS could get you into trouble. IRS could say you should be putting this person on W-2, deducting their social security taxes, other benefits. You have to put them on W-2. You can't have them on 1099. So remember, you have to balance control under immigration law with control under taxation laws. Otherwise, you could get into a lot of trouble. Short answer, I don't know how you can comply with US laws when a TN worker works on 1099 on a US sponsored job. Now, if it's a corp to corp arrangement, that is possible. And even there, the 1099 should go to the Canadian company, and the Canadian company should be paying their own employee. Okay? Anybody has a question about this, press *5 on your phone, please. *5. Anybody has a question on this issue, press *5. Okay, let us go to the next frequently asked question. Another very interesting question that was actually posted on immigration.com, and I moved it because I felt that people should understand how this works. The question was, what is the difference between an I-140 being withdrawn and an I-140 being revoked? Okay. Um, I thought this was a very interesting question, and it had certain elements that everybody in the community should know about. Okay. And guys, I want you to remember when I say community, I don't mean Indians or Pakistanis or people from South Asia necessarily. I mean our community of people who are immigrants or intending immigrants in the U.S. In the larger sense, we are all a member of the same community. So that's what I mean, and I think that's something that people in the temporary worker community should know about. Okay. A revocation means an I-140 was approved and then cancelled. So revocation means there was an approval first. If a case has never been approved, it cannot be revoked. It can only be withdrawn, or it can be denied, right? So a case, an I-140 that has not been approved, can only be revoked. Sorry, can only be withdrawn, or it can be denied. So let's say I file your I-140, and USCIS says, no, we deny this case. There are some problems. That's a denial. Everybody understands that. So I file your case. I'm your employer. Before the case gets approved, I send a cancellation request. That's a withdrawal. My case gets approved, and then I write to USCIS and say, I want to cancel this case. That's a revocation. Another circumstance of revocation is when USCIS says, oh, we approved this case in error. Remember, the case has been approved, and USCIS says, we approved this case in error. They can go back and issue a notice of intent to revoke and revoke the case. Or if they find any fraud, which is a very serious matter that should never be ignored, that has criminal complications, criminal law complications, that on an employee can operate as a permanent bar from entering the US with very few waivers available. Only one waiver actually. So when a case is approved and then cancelled out, it's a revocation, whether it is done by the employer or the government. If the case is still pending, it can only be withdrawn or denied. That's the way it works. Okay. Anybody has any questions on this I-140 revocation and withdrawal and what the effect is? Go ahead and press *5 on your phone, please. Any follow-up questions on this? *5. One question. Okay. Let's see. This is from Kentucky. Kentucky, go ahead, please. Kentucky. We can hear you, Kentucky. If you say hello, we should be able to hear you.
Can you hear me? Sorry, I was not on mute.
No, we can hear you. We can hear you. Go ahead, please.
Okay, all right. Yeah, hi, Rajivji. This is Vinay. I don't have the list of questions in front of me, but I think it was number 5 or number 6. And
yeah, I think I saw that.
Revocation.
Yeah, I saw that. I think your questions are related to this issue. So let me go to them. Give me 1 second.
Okay.
Yeah, I remember. You had done a very good thing. You had actually connected your follow-ups to your main question. So one of your follow-up question was, my PERM and I-140 were approved in the 4th year of H1. I am now in 7th year. If I-140 is withdrawn, okay, what you mean is revoked because your I-140 was approved, right?
Yeah, exactly.
So if the I-140 is revoked, first of all, can the employer refile it? And the answer is yes, they can. And can they refile it using the same PERM application? The answer is yes, they can. Can I get an H1 extension going forward based upon the approved PERM and pending I-140? Yes, Vinayji, you can.
Oh, okay. All right. Thank
okay.
You.
Now let me go back to I'm going to go back to your main questions. Your main questions were employer A filed I-140 approved. You left the employer, joined B. Then you left. When you left A, they said they might withdraw. You want to go back, but the online status says it's not withdrawn. I think what you can do is, if you have enough time, go ahead and apply for an H1 extension for 3 years. In the meantime, right away, you and the employer should file a Freedom of Information Act request, requesting at least all documents pertaining to the I-140. That way, within a couple of months, you will get all your documents from USCIS. If they have received the revocation request, you will get a copy of that also.
Okay. So do I just ask my employer to find a FOIA with the USCIS
and you can also do that. You should also do that. Both you and the employer do Okay,
Oh, okay. So both of us have to do that, and if just in case if there was a revocation letter, then I would be getting them back, right?
absolutely, absolutely.
Oh,
All right,
okay.
all right.
All right. Thank you.
Good luck. Okay, so that covers all our I-140 related frequently asked questions. Let's go to the list of questions and start serially. Jamfaz says my H-1B visa was approved in 2006, stamping 2007, worked in the USA 1 year, left in June 2008. In 2009, H-1B was revoked. Am I cap exempt? Yes, you are. I think you are cap exempt. The revocation does not take away your cap exemption. Anybody has a follow-up question on this issue, press star 5. Revocation of H1 and cap exemption. Okay, I'll go on to the next one. So that should be clear. Oh, there is a question. Let us see. All right, Florida, go ahead. I think you and I have been talking on Twitter too, huh?
Yeah, hello. Uh, Rajiv ji, I mean, I actually tweeted you, I mean, just few days back.
Right.
I have one question related to my I-140, but I'm not sure that this is related to
No,
the,
no, I can't. I'm sorry, I can't deal with unrelated questions right now. That will be at the end of the conversation. Stand by. Okay, guys, please follow my instructions. That way we'll get over this conversation very nicely and in an orderly manner. Okay, nothing new. Uh, our Kata 2011 says uh, my H1B and I-94 are good till 2016. Employer applied for extension. You got denial in December. Can I still work till Jan 10th? And the answer is of course, unless there is something in the denial that has a bearing on your existing approval, you can continue to work there. Okay. And if you file another H1B, um, because your status is still good till January 10th, you can always file another H1B extension with the same employer. And you can even use the same LCA. You don't have to get a new LCA. So I hope that clarifies the issues. Anybody has a question on this, press star 5. Any follow-up questions on this, press star 5. Yeah, so once again, I repeat, if an H1 is denied, it can always be refiled and you can use the same LCA as long as the old H1 is still valid. Okay. Then we come to Fani Churana. I don't like to give advice on filling forms. There are many reasons for this. One of the main reasons is that filling forms requires the person who's helping you to sign at the bottom, and we are not helping you in filling forms. But I can answer questions generically, and if that helps you fill forms, that's fine. You got your visa stamp in India under H1B, good till 2017. You lost your job after you came to USA. You went on to visitor visa, and the H1B was revoked. Then you got a new job. You got sponsored for a new H1B. You are visiting India, and you need to get a visa stamp. So the questions that are there, do you have a previous H1B visa? See, remember, visa is always the stamp on the passport. Visa is not, when the consulate says visa, they don't mean the INS or USCIS approval. They mean the actual stamp on the passport. So I can't tell you how to answer the question, but visa simply means the stamp on the passport. Next question is, were you denied any visa? Again, visa is the stamp on the passport. Is your previous H1B visa still valid? Again, that is the stamp on the passport. Okay. When you have a doubt, you can always say no to these questions and give them more information. But visa is always the stamp on the passport. And that should answer all your questions actually. Every question you have asked me relates to the same issue. Anybody has a question on this, press star 5. Anybody has a question on this, press star 5. Okay, they are done. Next question is Vinay. I already answered that question. This was the I-140 question. Then we come to Vijay Govindarajan. Let's see. There's a 221G twice regarding employer's information when you applied for H-1B. Then you processed an L-1B. There you again got a 221G. And they say since the H1 is valid, they cannot process L1B. That is nonsense. That is not true. And you can always withdraw the H1B and say, I just want to do an L1B. Okay, so you have stayed in USA only 16 months. Another company has filed cap exempt H1B in August. Case has been received. What is the possibility of my approval and visa approval? Can I go for premium processing? See, the problem that you have does not appear to be at the USCIS side. The problem is in the consulate. And I do not know why they are holding your case under 221G. 221G simply means we don't have sufficient documentation to issue you the visa. That can really mean anything at all. Something quite silly and small or something quite serious. So it is impossible for me to predict the chances of visa approval. Getting premium processing is a good idea because that way you go before the consulate as early as you can. Okay. So if you have a follow-up question, press *5. *5. Vijayji, if you are here or anybody has a follow-up question on what I just talked about, *5. Okay. Let's go on to the next one. What are the current I-130 processing times? You should be looking at the National Benefit Center processing times. Okay, NBC times, they are available on USCIS website. If you don't know how to get to them, you can actually go to our website, and there's many ways to get there. If you come to the footer under common topics, you will see processing times and status checks. Click on this page, it will bring you where you need to go. Okay, so that's where you go to check times, and times change from time to time as well. Folks, as I talk, I also monitor our tweets, and you can tweet to me either directly by following me, Immigration.com, or from our forums. I'm right now showing the forums on the screen. You can also tweet directly from immigration.com. Right here, there is a way to tweet to us. So anything you want to tweet, although this conference call is not that complicated, we have relatively easy questions. So just in case you want to talk with me and you can't get through, just do this. Okay, then we come to the next question. RDRD. L1B to H1B change of status approval timing and already pending I-140 approval timing related questions. Let me remember what is the question here. Okay, first of all, it's very important to realize that while a non-immigrant status can be trumped by a subsequent non-immigrant approval. So let's say you have an H-1B pending and a tourist visa pending, tourist change of status pending. If H-1B comes first and then tourist comes later, maybe tourist trumps the H-1. There is some conflict about that as well. But a green card cannot be trumped by a subsequent non-immigrant visa approval. So if I get my green card approval today, 485 is approved, and then the H1 is approved or the L1 is approved, that does not affect my green card at all. You don't have to worry about that. Your green card approval will always trump all other non-immigrant visas. Okay, so there is no worry, and I think that is the only real issue you have. If you are on the phone, press *5. Anybody has a question on this, press *5. I also want to add, guys, I again got an email, can we do conference calls on weekends? And my problem is I just don't want to commit to that because Weekends you can never predict. Weekdays I know I'm here Thursday, I'm going to do it. So I don't mind doing additional phone calls if we have a way of getting together at a short notice, but I can't give plans like that. So no, sorry. Okay, there is somebody probably on a voice over IP who just raised their hand. Go ahead, I can hear you.
Hi, can you hear me?
I can hear you. Yes, sir.
Oh yeah, I had a question. Actually, my mother has applied for a green card for me, and then
Hang on,
I'm
hang
trying
on,
to get a green
hang
card
on,
too for her.
hang on. I'm not asking for new questions, sir. That'll be at the end.
Oh, okay, sorry.
Yeah, please wait. Thank you. No, it's okay. You guys don't know all the process we follow. That's fine. Ashok M. Dhareshwar. Um, been on green card. Oh yeah. So you basically applied for an extension, used Form I-90. Second time you do it without fees, but you still don't have your green card. Okay. I do advise you, instead of appealing against the denial of the I-90, just file a new I-90 with the fees. Because the appeal could take a long time. You don't know how long it's going to take. Uh, and really that's not, in my view, that's not an issue, um, because even though the green card has expired, you are still on green card. You just don't have proof of it. What you are getting by filing I-90 is the evidence. And you said that you're planning to contact our office. I don't think you need a lawyer for an I-90 application. But yeah, if you want us to do a consultation for you, we'll be happy to do it. Um, my only concern in your whole story is that, have you established your permanent residence after getting green card? And did you at any time abandon your permanent residence? Those are the two issues. I-90, I think, is a relatively small issue. If you are on the phone, press star 5, star 5. But appeal, I think, is too long a process for you, Ashokji. I would not go for the appeal, personally, unless there is some other reason that I don't know from your description. It looks to me like you should just file a new I-90. Okay, let's go on to Hardik 8090. This is a very strange case, Hardik. I don't understand how they denied your E2 investor visa from Australia um, under 214B, which is intended immigrant. Your parents had migrated, but nobody had filed for your green card. There's something going on here that I'm not quite clear about. Of course, if they have denied your E2, which is usually not denied on 214B grounds, they're not going to give you B1, B2. H1B cannot be denied on 214B grounds. E3, which is an Australian equivalent of an H1B, probably is not, because E3 says you must have the intention to come back, but not, in other words, if there's a sliding scale. H1B doesn't care whether you have intention to come back or not. L1B doesn't care. H4 doesn't care. L2 doesn't care. I'm giving a very simplistic overview. On the other hand, B visa, F visa, J visa cares a lot. E visas are somewhere in the middle. All they require is some intention to come back. It really is not that big a deal. So E3 visa, I think, should be applied for. I still would like to know more about your case. I would like to study the case. I don't see how this didn't work out for you under E2. That's very strange. Something is not right there. But E3 certainly is also an approach that you can take. And this idea that we have to demonstrate assets or family, I think it's a fiction. Basically, if you are somebody who's reliable and somebody who's not likely to break the law, I think we can make a case for it. But I would like to know, why was the E2 really denied? That doesn't make any sense. So if you are here, you can tell me a little bit more. But I would certainly be happy to help you. But I am concerned, can I really do much good for you if the previous case had some issues that we don't know about? And E3 visa does not require that your sponsor has to be the actual employer. as long as they maintain the right to control over you, the fact that they are a staffing company should not by itself be a problem. Okay. Should you apply for E3 from Australia or Canada? That's up to you. I prefer, if you are living in Australia right now, to apply from Australia. Hardik, if you are on the phone, press star 5. Star 5, Hardik. If you have a follow-up question, oh, good, you're here. Okay. So, Australia. Go ahead, Australia.
Yeah, thank you very much, sir. Yeah, I'm also baffled by the answer that I got
I
from
really
your
am.
consulate when I applied
Hardik,
for E2
Hardik, I really am. I have never in my entire life heard an E2 visa being denied on 214B grounds. Something odd happened. Either the consular officer did not know the law fully, or, well, think about it. E2 visa is indefinite. You can have an E2 visa forever. Think about it. There is no limit on an E2 renewal. E2 can be renewed 3 year to 3 year, year to year. There are some variations there, but there is no limit on how long you can have an E2. 214B should not be a problem for E2. So something is not right. You may want to, while we are looking into your case, or if you decide for us to represent you, you may want to file a Freedom of Information Act request with the consulate. File an FOIA through the State Department. You can do it online. File it. I want to know what documents they have with you.
Mm-hmm.
I'll tell you something
So
interesting.
I need to get in touch with you later.
I'll tell you something. Hang on, Hardik, I'll tell you something interesting. 2 years ago, we had a guy approach us from, very nice guy, businessman family, really good background. But he was stuck somehow in this Tri-Valley University problem. But he didn't commit any fraud and never done anything wrong. Goes for his green card through his spouse. The consulate says you have committed fraud, and they barred him from entering USA permanently. They tell him go apply for a waiver. So he talked with 3 different lawyers. They said we'll do the waiver. When he came to us, I said waiver for what? You have not committed any fraud. Why should we apply for a waiver? I'm not going to apply for a waiver, because remember, the form that you fill out for the waiver actually says, I have committed fraud, I'm sorry, and here is my explanation. Why should I admit to something? In my view, if I have not committed fraud, yet under oath I say I have committed fraud, that is fraud. Think about it, right? So I refuse to do that. I fought with them for 2 years. I got all the information through the Freedom of Information Act request. Last month, they approved his case finally. No waiver, nothing. They backed off. They approved his case. So sometimes it can be, and I bet you the problem was that the consulate misunderstood the whole case. Okay, but I do need to know what
Sorry, can you repeat that? Sorry,
I bet you the problem is.
Difficulty hearing you.
I'm sorry. Let me get closer to the mic. I think the consulate has misunderstood the case. There's something odd going on. Okay, so get the Freedom of Information Act request rolling, and then if you want to do an E2, that's okay. If you want to do an E3, let's do an E3.
Okay.
Anything else?
Yeah, no, that shed some light in my case. So yes, I will be getting in touch with your assistant to schedule an appointment.
You can drop me. You can just write an email to frontdesk@immigration.com. Frontdesk@immigration.com. My email is help@immigration.com.
Okay, no problem.
All right. Good luck.
Okay. Thank you very much.
You're welcome, sir. Okay. Let's go on to the next one. We already discussed this. There is a question from Tina. Tina says, if I'm bringing a domestic employee on a B1 visa, can all the certifications be on the same certificate? And the answer is yes. There's no format or formal requirements. As long as you follow the checklist, you should be okay. It doesn't have to be on a stamp paper or a letterhead. It can be plain paper. There is no formal template, but because it is a contract, I would advise you to get a lawyer. Make sure it gets, because if you sign a contract with your employee, there have been cases here where employers have gotten into trouble and employees have gotten into trouble. Make sure somebody reviews that. Can the employer book travel after the domestic employee visa is approved? Yes, because that's the major hurdle. I mean, the employee can still be stopped at the airport when they land. Customs and Border Protection can still turn them around. I think most of these, if you look at, I haven't looked at the uh, Lima, uh, Peru website of the US consulate, but they will tell you that you need to bring papers with you that will be reviewed again at the airport when they land. So, but the major hurdle, the first hurdle is definitely visa stamping. After that, you can start the travel arrangements. Okay, star 5 if you have a question. Star 5, a question on this issue. Okay, we are whizzing through it quite quickly, so no worries, we'll have plenty of time to answer other questions. Oh, there is a question. This is Denver. Denver, if it's a related question, only then, please. Denver, go ahead. Denver, I can hear you. You just raised your hand. Go ahead, please.
You answered everything, Rajiv. Thank you.
Oh, excellent. I'm glad. Okay, excellent. Always a good occasion when we can cover everything. DV lottery. I am not an expert in DV lottery, but I know this. Please double check with somebody who's an expert. We never did DV lotteries. I, in my entire life, did one DV lottery application and then realized don't need a lawyer for this. Why do I have to be involved? So we stopped taking DV cases. But I do know this, that you've got to complete your DV application within that fiscal year. If you don't, it's lost. You have to apply again. Okay. If you're on the phone, press star 5. Star 5 if you're on the phone. So DV application has to be completed. Green card has to be granted in the same fiscal year, so October 1st through September 30th. So this fiscal year, current fiscal year started on October 1st. It will end on next September 2016. That's the way fiscal years go. Okay. Chandi K. I'm on H1B expiring 31st December 2015. Extension filed. LCA for location A. I want to move to location B, different states. Within few months, though the same employer in a same employer or different one. Okay. If I choose the same employer, can I move to location B before my extension process is complete? Yes, you can. So whether you move to a new employer or the same employer, when you file for the transfer over or amendment of the H1, you can start working when the H1 receipt comes. Okay. Now, if I choose any other employer, is it possible to switch without hampering my extension? So what you're saying is if my extension is pending and then I change over, does that become a problem? Here is the issue here. Let's say I'm working for employer A and my status is expiring January 1st. We had a similar discussion just a few minutes ago. So January 1st, in that case, his was expiring January 10th, if I remember correctly. So let's say my H1 is expiring January 1st. In December, I apply for my H1. Extension is pending. Now I want to change over to employer B. If there is life left on your current H1, you can file applications through B, C, D, E, F, no problem. But if you apply after January 1st, when your current H1 is expiring and the only reason you are here is because your extension is pending, then you could have a little issue. What would be that issue? That issue would be this. When the second case is denied, I'm sorry, take that back. When the second case is decided, the only way they will give you status within the United States is if your old case, the extension, has already been approved. If the extension is still pending or denied, if the B H1 is approved, you'll have to go outside USA for visa stamp. Okay. I may not be understanding your situation completely. I'm trying to, but I think that was your question. Is it possible to talk to my current employer to shift me to a different location until my extension process completes on my current project, work remotely. I don't understand this question at all. I'm not sure I'm following you. If you're on the phone, I would love to talk with you. Press star five, please, if you're on the phone. Oh, excellent, you're here. Good. Let's see if we can understand what the problem is. You were the first caller on the phone too. Please go ahead. Today's call.
Hi, sir.
Yeah, go ahead.
Thank you for answering the question.
Yes,
Can you hear
ma'am.
me?
Yeah, I can hear you fine. I'm just trying to. Yeah.
Yeah, I meant by the third point that I can work remotely like for a few days. So, is there any problem if I ask my employer to shift me to a different project and to a different location which I want until I get my approvals done
Okay,
from the USCIS?
hang on. Let me understand this. So let us say you are working in Washington, D.C. They have filed for a change of location to, let's say, California. While the change of location to California is pending, can you work from, let's say, Baltimore, which is your home, or on another project?
Can I work from Washington?
Oh, can you work from Washington, D.C. on another project?
Yeah, which is in California.
The answer is no, you cannot. You definitely should not, for a couple of reasons. One reason is when the project or the end client or the job description changes, an amendment should be filed. Okay. However, if the employer files an amendment for the location, as soon as the receipt comes, you can start working at that location. You don't actually have to wait for approval.
Okay.
I may have confused you more than helped you, but I hopefully I have given you enough information that you can ask the right questions of your lawyers.
Okay.
Do you have any? I can talk with you another couple of minutes if you're not clear. You can ask me your question.
Oh, I'm good. Yeah.
Okay, very good.
I'm good.
Good luck to you, ma'am.
Yeah. Thank you, sir.
You're welcome. Sometimes the laws can be so complicated, even I doubt if I'm making myself clear. So, feel free to tell me, you don't make any sense. Okay, A.K. Virani, I have known this gentleman for a long time in my Facebook, Twitters, and our conference calls. So I already talked with him. He was here quite early, and I recognized his phone number because we get caller ID as well as phone number. So I've answered his question. The question was this, just for the community. I have an H4 visa stamp. I come to USA. 3 years later, my extension is approved by USCIS, but my stamp has expired. Now, when I travel, do I have to get a new visa? The answer is yes. Just because your H4 extension has been approved by USCIS till 2018 does not automatically extend the visa. Visa is given by the consulates. When you travel, you have to get another visa because the old one expired. Okay, so last two questions. Imi Rav says, I-140 from multiple employers. So I've got an I-140 approved in September 2010 through one employer, A. They had some financial issues. Position was eliminated during downsizing. I moved to employer Y, who processed my perm, received H1 extension based on employer A's I-140 for 3 years. After 6 months of employment with employer B, I guess it's Y you mean, I don't know, went to India for stamping and was stuck for 16 months. I-140 was approved with consular processing. Eventually, visa was stamped, but H1 was revoked. So I'm no longer working with them. I'm a little confused here. These facts are not clear, but let's keep going. Meanwhile, moving to a MNC employer. I don't know what MNC means. C in India, who transferred my H1 based upon employer C's approval. Okay. Employer C processed my perm and is ready to file for I-140. You have actually, I think there's some confusion in the questions that you've asked. I hope you are here and you can clarify this because this doesn't make sense. But let me go on to the questions and I can maybe generically answer these questions. Employer C can request capturing of the original priority date. The answer is yes. Once an I-140 has been approved, that is the current thinking of the government. Tomorrow it could change. Once, and I have a blog entry on this. If you go to my blogs, there's an entry on can I take my priority date with me, even if the I-140 is revoked? And the answer is, easiest thing is if the I-140, old I-140 is not revoked, definitely you can take your priority date wherever you go. Second, if the I-140 is revoked by the employer, can I still carry the priority date forward? The answer is yes, as of today, that is true. If the I-140 is revoked by USCIS for fraud or misrepresentation, they will not let you carry the priority date forward. If the I-140 is revoked by USCIS for erroneous approval, that they made a mistake, they shouldn't have approved it, you cannot carry the priority date. Okay, that is the bottom line. Will USCIS inform employer that the I-140 date is being ported? They do not. Old employers do not get informed if your priority date is being ported. If the situation changes, will I be able to use employer B's I-140 in spite of the earlier port request? And the answer is yes. This is not like, here's my I-140 approval. Date has been ported to a new I-140. Can I use the old I-140 out of which I had ported? Sure. If the job remains there, just because you took that date and took it elsewhere does not destroy that I-140. If you're on the phone, press *5. *5. Okay. The last question for the day. I have traveled, my STEM extension has been approved. Okay, but the EAD card is still in the mail. So there are two components to STEM extension: approval from the DSO, then filing with the USCIS. USCIS approved my case, but I cannot get my card. It was returned. They couldn't deliver it. Okay, so can I return to US without EAD card in hand? I think you can. Normally, you cannot travel outside USA while STEM extension is pending. So I'm assuming that you did not travel while the extension was pending. If you did, you have a big problem, because as far as I remember, you're not allowed to travel while the STEM extension is pending. If you traveled after the extension, the fact that you don't have the EAD card in hand, you should still be able to come back, because at the airport they can verify, CBP can verify that your extension was, your EAD was approved, although you don't have it in hand. Okay, if you're on the phone, press *5. *5. Mahita? Okay. Yeah, Mahita, go ahead, please. I can hear you.
Thank you. The thing is, as I explained in the post, my card was supposed to be delivered to me before I was supposed to travel, but apparently it didn't. When I called them, they told me that for me to go for another service request, it will take me almost a week, and for them to process it, it takes almost a month. But I'm planning to get back to work by a week.
Okay, hang on. Mahita, I have a question for you. Did you travel outside USA? I cannot really understand you very, very clearly, but let's try to do this. When you traveled outside USA, when you traveled outside, did you already have a STEM extension approval from USCIS or no?
Yeah, they did approve my extension, and they did mail my card to me. It's just that I didn't get it by the time I move out.
Okay, I think you should be able to. I think you should be able to travel. Do you have any evidence of your STEM approval, extension approval?
My status ID. They do give me a receipt number for every, if I'm not wrong. So my case status just shows that my card has been delivered, but not. It has been sent back to USCIS.
Okay. I think you should be able to travel with a copy of that take a copy of your I-20. I'm sure you have your I-20 with you. I-20 should also show that you
I
were,
do.
yeah, you were. It will show that you were approved for, recommended for an EAD extension. In addition to that, you might have your receipt for the filing of the EAD. Did you? Do you have your?
I do not have my receipt.
Okay.
Oh yes, I can print it out. It's an online receipt.
Take that receipt with you. Take the screen printout showing it was approved. Keep your I-20 with you. I think you'll be able to come back, Mahita.
Without the EAD card in hand. I do have my offer letter with me.
Yeah, I think
saying that I do have a job in there.
good point. That should also be, I should have mentioned that.
Hello.
I'm glad you brought that out. Yes, you should also be able to show that you've got an ongoing job. Yes, good.
Yes, and I do have my valid I-20 that's been issued for the approval of STEM extension from our university.
Right, and I think you'll be able to make it in. They might put you in secondary inspection at the airport. You may be delayed an hour or two, or maybe not. But the worst case scenario, they will just look at your records. They can go online, check on the computers what your status is, and you should be okay.
Okay, thank you.
You're welcome.
You're
welcome. Good luck. Okay, guys. Anybody has any question, press *5. Anybody has any question, new question, old question? 4. Okay, I've got 4, 5, 6, 7. All right, we'll do the 7 people. Anybody has any question, press *5. I will stop at 7 otherwise. Okay, I'm going to start calling on people in the order that they logged in. Okay, so if you logged in earlier, I'll get to you first. So first in, first out. Let's see. Oh, I guess you have a follow-up question. Go ahead, Colorado. Go ahead, please, Colorado.
Hi, this is Sandik. It's regarding the 16th question.
Yeah, let me get to that. Just give me 1 second, Chandik. H1B expiring, extension, same LCA location, da, da, da. Yeah, go ahead. I remember.
Yeah, it's about the second question. If I choose any other employer, is it possible to switch without hampering my extension? It's about that. I want to ask if I apply, if I change my job after my expiry date, like 31st of December, at that point of time, how can I go ahead and ask my new employer to work on my extension thing?
Not sure I understand, Chandik. I didn't understand what you had written. I don't understand what you're asking me. So let's try to break it down. Let me ask you the question so I can understand. Your question is, I want to do an extension and I want to do a transfer to a new employer, right?
No, actually, I don't know whether I just understand this that extension is same to as a transfer.
Actually, extension can be done through the same employer or through another employer. That's not the issue. Are you asking me, can I do an H1 extension with my current employer as well as a transfer over to a new employer? Is that what you're asking me?
I got my answer clarified for the current employer, but okay. I didn't get your point about the another employer.
Oh, okay. Let me explain. Let me explain to you. Let me just check my tweets also. Okay, these are just new followers. Okay. Here's what I was saying. What I was saying was, let's say you are in that time period where you have to apply for extension of your H1 because your current H1 is expiring in the next 1 to 3 months, right?
Yes. Yes.
Now, let us say you have filed for your extension already and there's only 2-3 months left on your current H1. Okay. Now, first situation is, if I want to apply for a transfer to a new employer, can I do that while this extension is still pending? Right? Is that your question?
Yes.
And the answer is of course. There are 2 possible situations there. One is that your initial H1 is still valid. You have only 2-3 months left on it, but it's still valid. If it is still valid, you can apply for as many transfers as you like.
Okay.
There is no problem.
Okay.
Things become more problematic if your extension is pending, but current H1 has expired. Are you following me?
Mm-hmm.
Now what
Yes.
happens? Now what happens is you can continue working with the same employer up to 240 days while your case is pending. No problem. Are you with me so far? Ma'am?
Yes.
Okay. However, if you apply for a transfer now, when your old H1 has expired, in order for the transfer to be approved within the United States, your H1, old H1 extension must be approved when they decide your second case. If it is not already approved, if it is denied or still pending, they will make you go outside USA for visa stamping. That's what I was saying.
Okay. Okay.
Make sense?
Yes.
Okay. Good luck.
Thank you.
You're welcome. Okay. There's my Twitter friend. Go ahead. Florida, go ahead. Go ahead with your question. Now is the time.
Hi. Hi, Rajivji. Yeah, actually, my name is Arlington. I'm from Florida. My
Yeah.
H1B actually max out is going to happen very soon in Feb 2016. My question is, my farm actually was filed very late. I mean, on my in my 6th year. So I think might have to go out because farm will not be approved. And in this scenario, in order for me to stay in US, stay back in US, my employer is saying that I'll have to get my I-140 approved. I mean, even after my farm is approved. So in that scenario, I mean, my question is, if I exhaust the total full 6 years in US, and if I go back to India, and even after my I-140 is approved, I mean, when I'll be in India, so will I be able to file an extension to my employer on this H1?
Absolutely. No problem at all. You know, before 2005, about 10 years ago, the law was it 2000? I think it's 2005. The law was, in order to get extension beyond 6 years, you must be currently on H1. So if there was even a 1 day gap between old H1 expiring and wanting to get a 7th year extension or a 3 year extension, you had to have existing H1. That is no longer the law. So even if there's a 6 month gap, 1 year gap, or 3 year gap between your old H1 6 years expiring and you becoming eligible for 3 years of H1 again, or 1 year of H1 again, you can do it right away. There is no problem. You don't have to have any H1 left from 6 years.
Okay, Rajiv. I mean, I just came to know, I mean, from one of my colleagues that he was raising this point, so I just thought of asking.
Yeah, this was the law. Your colleague is right. He's just 10 years too late for that interpretation.
Okay,
Alright.
fine. So yeah, because I actually tried to book my air ticket. I mean, in January. I mean, keeping some days left in my H1B.
You don't
So
have to do.
I
You don't have to do that. No, you don't have to do that. Let me ask you a couple of quick questions. When was your POM filed?
My palm filed was actually on 12th August.
12th of August of 2015.
Yes.
When is your H1 expiring?
My H1 is expiring February 28th.
Feb 28th. Okay.
Yeah.
So between Feb 28th, Feb, March, April, May, June, July, 5 months gap. Do you have any time to recapture? Have you been outside USA in the last 5 years?
No, actually, I mean, once I came to US in 2010, I've never gone back to India. So this is a continuous stay.
Okay.
I mean, in fact, I was on L1, so it was a change of status from L1 to H1B.
Okay. So I have only one thing to add for your knowledge. You are right. You have to leave, or you can go to school and get OPT and start working on OPT. or if you don't want to work and just stay for 5-6 months, you can try to get a tourist visa. You have those options, okay? But if you are leaving, or even if you're staying, remember one thing: you are entitled to file your H1 extension 6 months ahead of time. So you can file in February, you can file for H1 extension. It will not be effective. It will not be effective before August 13th, but you can file it now. You can file it in February.
Oh, okay. So, Rajiv, I mean, my understanding was, I mean, unless my I-140 is not approved, I am not eligible for
don't.
filing any more extension.
No. The thing is, your perm was filed on 12th of August. 12th of August 2016, you become eligible.
No, 2015. Sorry, 2015.
Yeah, but
this year.
I understand that.
Right.
12th of August 2016, your perm would be pending 1 year.
Right.
That means from that date forward, you're entitled to 1 year H1 extension.
Okay. Okay, now I got it.
But you can file it 6 months ahead of time, which means in about February. You can file for your perm extension.
Okay.
It will be effective in August, but it's good to get it started as early as possible.
Okay. Now I got it, Rajiv.
Okay?
Thank you so much.
Oh, you're welcome.
Thank you so much for your time.
You're welcome. Good luck, sir.
Suggestion.
Good luck. Okay, let's go on to California. California, go ahead. I can hear you.
Hello, Rajiv. This is I had actually sent you an email. My sister sent it, Veena Shivhari, and I explained my situation, but I will reiterate it. I'm working on H1B, and my job ends in 4 weeks.
In 4 weeks?
I
Okay.
get approved,
Okay.
and I have an offer from a company that I think I will accept because I don't have enough time to keep searching before mid-Jan when my current job ends.
Okay.
Now, if I take this offer with the company that I have, let me call it Company A, they will file for the H1B before the end of current job, and I will get an extension based on the I-140 approval. I'm currently in my 7th year. But if I leave this company in maybe 3 months or so, because I'm already speaking with other companies, can I transfer my H1 from this next job to the one after that, based on even if the I-140 that is correctly approved gets cancelled or revoked by my employer?
See, this is a very difficult question to answer. This is what happened in one of our cases last month. Somebody kind of like in your situation came to us, and he had about 1 year and a half remaining on his 3-year H1 extension, which was up to 9th year. So he got 7th, 8th, 9th year approved. Okay. His only 1.5 years is remaining. So he wants to know, my I-140 has been revoked by the old employer. Can I still get extension of the H1? And that's what you're asking, right?
Well, it is slightly different.
How?
My current, assuming that my current employer revokes my I-140 after I have changed to the next employer.
Right.
But if I change from next employer to an employer
That's
after
exactly the situation. There is no difference. That's exactly the situation. Okay. So what I told this guy was, I said, listen, I doubt very much I can get you an extension because there is no I-140. But what I can do is, I can try to argue that you have already given me 3 years, out of which 1.5 year is remaining. Give me only that 1.5 year. They gave it to me. So even though the I-140 was revoked, they gave me the 1.5 year that was remaining from the old extension.
I see. Okay.
Will they do it again? I don't know. but they did give it to us, and this was just last month. In fact, that reminds me, I should put a blog entry on that. I forgot to do it. I've been so busy. People during holidays get a little freer, but not here. Things have been very, very busy. So when I get a minute, I'll explain that in further detail in my blog. But definitely, that's what happened with us last month. Will it happen to you or not? I don't know. Certainly worth trying.
So, Rajiv, what you're saying is it happened in the case that you're talking about, but this is not something that would happen necessarily.
I don't know because USCIS, see, there are fringe issues. Are you an IT guy? Are you an IT guy? Are you a technology man?
Oh, no, I'm not a software professional. I have an MBA and I work in business kind of roles.
Okay, so I don't have a good example from MBA, but the problem is there are certain things when you get into tertiary issues, you can have documentation of primary issues. Everybody knows what the primary issues are. You can have documentation of even secondary issues. But when you get into tertiary issues, there really is no documentation. Okay, so all you have to do is use your common sense, use your persuasive arguments, and hope for the best. And I can't say that that's the precedent. I cannot say that this will happen again, but it did happen for us. Okay.
Okay.
So in other words, don't bet your farm on it, but it's worth trying.
Okay.
All right. Good luck.
This is helpful.
Very good. Good luck, sir. Okay, so we have 4 more people. Let's go to this one. Is also looks like a voice over IP. Go ahead, please. Voice over IP. I can hear you.
Hi, I had a question. My parents, they have filed for me to through the F2B category to get a permanent residency. They filed for me in 2009, and my priority date is in the next few months. I'm currently in the US under H1B visa. The problem is my parents, they haven't traveled to the US for the past 3 years. I was wondering if there would be a risk if I file an application, or do they have to come to the US? What's the likelihood of their green card to be taken away when they arrive, or is it a good idea to apply for an SB1 visa?
Okay.
Before they come.
Okay, I'm not entirely clear. I understood everything. You have an employment-based case going, right? That's a separate issue.
Sorry, can you repeat that?
You have an employment-based case going, right?
I have an employment-based visa, but I'm trying to get the green card through my parents.
Oh, through your parents.
So I have an H1B visa.
Okay, and your parents are currently living in their home country.
That's right. Yes.
How long have they been living in the home country without coming to USA?
3 years and 3 months.
Yeah, 3 years and 3 months. The problem is, if a US green card holder has been in outside USA for 1 year, their green card is automatically cancelled. Okay. And you already know that. You know that there is an SB1 visa, also called returning resident permit. The only way to revive that green card is if you can convince the consulate that the delay was for reasons beyond their control and they wanted to come back but they couldn't. If they get their SB1, they can apply for your green card after they come to USA. That's what I would recommend, because right now I don't think they have their green card. They can't really apply for it.
I see. So if they just come back to the US, the green card will be removed at the airport. Is that 100%?
Normally, what happens is, normally when they land at the airport, first of all, this is another issue. First of all, they might not even be able to get tickets to come to USA. Why? Because the airline is required to check their papers, and when the airline sees that they've been outside USA for 1 year, they will decline to issue them a ticket. Okay, first problem. Second problem, even if they are able to get a ticket, when they come to USA, Customs and Border Protection will tell them, if they find out that they've been outside USA for more than 1 year, and they probably will find out, they will say, okay, we are taking away your green card, we are letting you into USA on parole basis, but you will get a letter from the court, immigration court, for deportation and cancellation of your green card.
I see. And that will jeopardize my case. Is that right?
That does not help your case. I mean, if they have filed your green card and they are, I mean, that will not really help, because that means your green card is gone anyway.
Okay. I see. So if they go to the consulate and get an approval for the SB1 F1 visa, is that
yes,
going to
yes, because
if
they get SB1 visa, then they can apply for your I-130. Then I have no problem, because their green card has been returned to them.
I see. Okay. So do you think I can contact you to help me to apply for this?
Look, I don't want to waste your money. I will tell you this: unless there are extraordinary circumstances, SB1 for somebody who's been gone for 3 years is very difficult. Okay, but if you still want a consultation, I'll be happy to provide you whatever input I can. Go ahead and send us an email. You can just write to me directly, help@immigration.com.
Okay.
All right.
So can I just ask one final question?
Of course.
What if I just submit my change of status documents and then hope that they don't check to see if
no. Don't do that. Please don't do that. It's not worth it.
Okay.
Okay.
Okay. Thank you very much.
You're welcome. Good luck. I always tell people, in USA we keep the immigration laws so complicated because poor lawyers have to eat too. Really I mean, I've worked in so many different areas of the law. I've litigated business law, private international law, even antitrust laws. I've done all sorts of things. Immigration law is by far the most confusing area of the law. That's why I get very nervous when I get opinions from lawyers who think they have all the answers, or from HR people, because nobody has all the answers. We have to be humble enough to know I could be wrong. I want to go double check. There's so many exceptions to the rules. Let's go to New York. New York, go ahead, please. New York.
Hello, Rajiv. Thank you for taking my call. Sorry, I joined late. So I had a question in regards to the question number 9.
Oh, 9? 1 second. Now, the I-90, Ashok. You're Ashok, right?
No, the RD, question number 9.
Okay.
So it is related to H1B change of status and timing related to that.
1 second. Oh yeah, and I answered your question. When you listen to the recording, you will know what I said was no subsequent non-immigrant visa approval can trump an approved green card. So if you have an approved green card, tomorrow H1B gets approved or L1B gets approved, no problem.
Thank you so much, sir.
Welcome.
I missed, I joined a little late.
I know. I mean, your basic issue was quite simple. Good luck.
Thank you so much.
You're
Thank you, sir. Bye.
Bye. Hey guys, I have been on both sides of the equation. I came to USA in student status, F1 visa. So then OPT, then H1, then green card. I understand this pain from every possible angle. All right, let's go to North Carolina. I was recently in North Carolina, actually, very good visit. Go ahead, North Carolina. We can hear you.
Hello, Rajiv. This is Sarvesh.
Yes, sir.
From North Carolina.
How are you, sir?
Good. How are you?
Very good.
First of all, thanks a lot for the previous advices that you have given, suggestions.
Of course.
I have 2 questions. One related to moving from H1 to green card.
Okay.
And what is the, are there any formalities when you move from H1 to green card? And second is related to how long can you be outside of the state in your home country on green card?
Okay.
So the first question is.
Yeah, no, I got it. I got it.
Okay.
So give me 1 second. Let me collect my thoughts here. Repeat your first question. Like it kind of completely slipped my mind. I think I'm getting tired. What was your first question again? I'm sorry.
But are there any formalities
Oh
on
yes.
the
Oh yes. Oh yes. I got it. I got it.
green card?
So the issue is this. I'm on H1. Tomorrow I get my green card approval. Is there any song and dance I have to do? Right?
Right.
And the answer is nothing. All you have to do is just take your green card to your employer and tell them, please update my I-9. Now I have a green card. That's it.
Okay. Here is the situation. We're just trying to give you where I'm coming from. I have an employer A who has filed my I-140. I retain an I-140 through them. And then I had H-1B transfer while retaining this I-140 from my previous employer. And in meantime, we applied through my wife for green card in EB1 category. And right now we have the EAD in that situation as on spousal basis.
Okay.
So here, when I work with a newer employer, I am going to work with a newer employer, not with the previous two employers.
That's okay. Look, hang on 1 second. If you get your green card through your wife, there really is no problem because you are a derivative beneficiary. All you have to do is update your I-9, nothing more.
And no duration of 6 months or 180 days applied.
No, because you are a derivative. You are a derivative. There's nothing at all you got to do.
Okay. That's one. And the other is how long can you be outside of
That's a pretty complicated issue. I'll try to sum it up in 2 lines because we don't have any more time than that. First of all, if you leave USA with the intention never to come back, okay, so I pack up my bags, I send everything to India, Pakistan, China, wherever I'm from, I send everything back, I'm never coming back, okay, and after one day I want to come back again, technically I have already lost my green card. USCIS, if they can establish that I left with an intention never to return, my green card is gone. Okay, so technically.
So what if you have any kind of a collateral?
No. Don't get into what you can prove. I'm just giving you the law first. Okay. So if you have the intention never to come back, even one day is too much. If you have the intention to come back, let me finish. I won't have time to go over all the details. This is a very long topic. So just before you make any plans, set up a formal consultation either with me or some other lawyer. Make sure your issue is discussed so you understand what the law is. This is not an easy topic. It depends upon the facts of the case too. Second thing, if you have intention to come back, we have to look at how long are you gone. Less than 6 months is usually no problem. More than 6 months, less than 1 year is usually no problem unless you have taken a job in your home country. Then it can be a problem. If it is 1 year or more, you've lost your green card. However, you should definitely look into filing a re-entry permit, which allows you to stay outside USA for up to 2 years. You can come and go as many times as you please. I have a lot of material, lot of discussion in our videos as well as in our blogs on how to file re-entry permit N470 to preserve your naturalization benefits. Read into all that. I won't be able to cover it in 5 minutes or even 15 minutes. There's a lot going on there. But when you come to that stage, you should do a consultation. Losing your green card is a serious matter. Okay?
Fair enough. So definitely if you go on an extended vacation like 3-4 months, just on a vacation.
Not a problem. Less than 6 months with an intention to come back is not a problem.
Okay.
All right?
There's nothing like you have to submit or
No,
anything.
no,
You
no, no.
just
I'm
go
not
ahead
worried.
and
Less
apply.
than 6 months, I'm never worried.
Okay,
All right.
sounds good.
Good luck. Okay. Last community member of the day from Texas. Texas, go ahead, please.
Hello, Rajiv. How are you?
Good. How are you, sir?
I'm good. I'm good. I have one concern regarding the perm processing. My perm processing is still in progress, and my H1 getting expired very soon in the month of October. I was wondering if I file a L1A visa, can I get one more year extra to work or not?
How many
Beyond the
years?
6 years
How,
of
how
H1B.
how many years of H1? 6 years?
6 years getting complete by my 28.
Yeah,
It includes
but
all my time.
you realize L1B total time is only 5 years, not 6.
L1A.
L1A is 7 years, but I think there is a limit. There is a limit. I forget.
Okay.
I forget how early. I think, again, don't quote me on this, but I think you have to apply like 6 months before your current H1B expires, so that you can get your 7th year. Yeah, you will be able to get 1 year if that particular requirement is met with.
Okay, all right.
All
Just
right.
little bit more related to same. If I get my I-140 approved after 6 or 8 months, do I need to apply again H1 or it will be extended through L1A only?
I think you are a little confused about. Let's talk a little bit more about what you understand. L1A.
I'm saying that if I apply L1, go ahead, sir.
If you get L1A, and then you file, are you saying you will file an EB1 green card? Is that what you're saying?
No. What I'm saying, if I file L1A and I get like one more year extra on 6 year of H1B,
And then
my green card,
then you become eligible for H1 extension, either because your perm has been pending 1 year or your I-140 gets approved. Is that what you're saying?
Okay, I can again get back to H1
Yes,
and get an
sir.
extended my
Yes,
Is
sir.
that right?
Yes, you
Okay.
can, and you will not be
All right.
subject to the quota. No problem.
Okay, sir. Thank you very much, sir. That's my question.
Oh, you're welcome. Guys, as usual, great conversation. I love talking with all of you. Thank you for being here, and thank you for this opportunity to be able to speak with you. I'll see you again in 2 weeks. So take care and good luck. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.